hearing. So, due process hearing, that happens when things have, all the things, with the school, they're just not working. You guys are at an impasse. It's not happening. What you want, your goals, you wanted them to happen. The school is saying, you say yes, they say no. And you tried all that you can. And now your only other option, or let's say your best option, is the due process hearing. So special education cases are litigated administratively. So the trial is called a due process hearing. The people that run the due process hearings are independent hearing officers. They're contracted to hear the petitioner's claims. In DC, hearing officers contract with OSSI, but they don't work for OSSI. Hearing officers directly they control all the aspects of case management for the case. Due process hearings are short. It's a short timeline. They play out over 75. It's a 75-day timeline from the date you file your complaint, and then you have to receive your decision within 75 days from the time. So from the time you file, you have your hearing. The hearing officer is writing the decision, and then you have your decision within 75 days. That's one thing that's great about due process hearings, and it doesn't take very long compared to like civil litigation. And that's one thing to keep in mind. I had a case recently. We were going to due process hearing, and the school's counsel was like, they filed a motion to enlarge, and they were like, we need like an extra month to file our response. And I objected to that. I opposed their motion, and the hearing officer was like, we don't do that here. It's a 75-day timeline. Like, we're not going to give you like a month to respond and then another month to prepare. And it just was like, it's a 75-day timeline. You're not going to be doing a due process hearing over a year or 6 months. The hearings can be expedited if they're related to discipline. And the hearings are held at the Office of Dispute Resolution in Northeast. So filing a complaint. Complaints should include basic facts, a list of legal issues, and general proposed remedies. Who can file? Parents can file. And parents can file a complaint regarding any matter relating to the provision of FAPE, a free appropriate public education. And LEA can also bring complaint against a parent in certain circumstances. If the parent refuses to consent for an initial evaluation, or parent has requested an IE and the school wants to defend their own evaluation. A child over 18 can file, and if they have their educational rights, their own educational decision-making rights. What can you file about? Any denial of FAPE against the student by the LEA or SEA you are naming in your complaint. Alleged violations must have occurred not more than 2 years before the date of the filing. The party knew or should have known about the alleged action forming the basis of the complaint. There are statutory and case law exceptions to the statute of limitations. Petitioner always bears the burden of proof. The burden of persuasion may shift from the petitioner to the LEA if appropriateness of the IEP or placement is an issue, and first, the petitioner establishes a prima facie case that the IEP or placement is inappropriate. What we found with the burden of proof is they made this change recently, but it doesn't seem to really have changed that much because you still have to put on your case. And so once you put on your whole case, and then it doesn't really feel like we thought it was going to feel as far as a burden shift. But nevertheless, that's what the law is. And the burden can only shift on the IEP and placement. That is not a unilateral parental placement. Common evidence at hearings. So one thing that's great about a due process hearing is the type of evidence that you can provide or that can be introduced at a hearing. There's documentary evidence. So school records. And here's when I was talking about memorializing things, this is why. Letters by parent and attorney to the school. So I use this often as far as I write when you have a case, if you never know when you're going to go to a due process hearing, and so you want to document what is going on. So you can write a letter to the school and say you didn't do this, and these are the things that happened, and then you copy your client, you write it to the school. And then you put that letter in your evidence for your due process hearing. The letter that you wrote to the school, that can be part of evidence. You can, so, if you write to school a letter and they don't respond, I'll say, like, second request for evaluations, third request, fourth request, fifth request. Keep all that information, and it looks beautiful in evidence that you have, like, hey, look at this. I requested 5 or 6 times. And if the school, if they respond, they do. If they don't, you have, information. If they do respond, I have yet to see, not DCPS, definitely a DCPS school respond in a letter form and say, hey, actually, this is what's going on, and write you a long letter back. That typically does not happen. It could, and it would be great. And then maybe you would be not going to a due process hearing if they were that responsive. Evaluations, you put evaluations in your documentary evidence, medical records, and then your testimonial evidence. You're going to have your parent testify, therapists, experts, that have information, educational expert, evaluator. And then as far as using experts, attorneys often find an expert helpful to help them determine the next steps, appropriateness of an IEP and placement issues. I can tell you, I used to practice where we did it. When I first started doing special education law, we didn't use experts. And I mean, I don't even know how we did it because it's really hard if you have a really like meaty special education case to go forward on a due process complaint without someone that can testify besides just your client. You don't want to go to a hearing to talk about, something that's inappropriate, that's going, a denial of faith, and you have just you, who's the attorney, and your client, and that's it. That's not a winning case, typically, if you really have some really tough issues. You need someone that can testify about, an IEP, why it's inappropriate. You need more than just your parent to go into a hearing. Also, hearing officers don't give a lot of deference to parents. A lot of times our clients will think, oh, when the hearing officer hears me, he's going to really be shocked. And they are not shocked about much. So you want to make sure that you have an expert. The hearing officers care about what experts have to say. And it could be a speech language pathologist, an occupational therapist, whatever your issues are. You want to make sure you have someone that can testify about those issues. Why retain an expert? It's just like I talked about. Parent has a burden of proof. Expert opinion is sometimes necessary to prove issues. It's a lot of times necessary to prove issues. And experts can help in understanding a child's needs. They can discuss the appropriateness of a proposed remedy. I mean, I think sometimes as attorneys, we get so involved in these special education cases, and we know the issues, and we're frustrated with what has happened. And it's like, if the hearing officer, if I could just like tell the story, but it's like, you cannot tell the story. You have to have people in place, your witnesses that can tell this story. So you want to make sure that you're considering whether you need an expert or not, and what kind of expert you need. The expert costs are vary. The expectation is that the firm will pay the cost of the experts. An educational expert often retained to do an independent evaluation of educational need. They can be from $3,000 to $10,000 for investigation and hearing. It just depends. We have experts that we use that we can recommend, and we can tell, you will have to negotiate with the cost with them, but we can tell you people that we have used and that we can recommend to you to use for hearings. Yes.
Question about the expectation that the firm will pay. Mm-hmm. My colleague here from the federal government, perhaps in-house counsel who would like to do these cases, doesn't have that pot of money. How do you handle that? Should they not take a case to begin with? Can you sort of go for a case that doesn't look like it's going to require an expert? How do you handle that?
The latter. Will you be able to repeat what you're saying? Yeah. So essentially, if you have access to litigation funds, then you have access, and moving forward with due process, paying for an expert and the associated costs, then you should be okay. We are screening for that on the offset at placing a case, so that if you do not have access, we don't want to give you a case that we think at that point an intake is likely to lead to litigation, and we don't want anyone to take it on and then be stuck with this bill. So we do have a good sense based on our experience which cases are going to be more or less likely for litigation. In the very rare occurrence, which maybe this happened once years ago, I mean, it really hasn't happened, fortunately. If you were to take a case that then moved to litigation unexpectedly, no one's going to be left hanging with the pro bono attorney or the client.
Yeah, yeah. So the question was, what would an attorney do if they were taking on a case and they needed to get an expert, but they didn't have like litigation funds to take on an expert. And what Jen was saying is that we screened for those cases, so we wouldn't want to assign a case to an attorney that didn't have the ability to have an expert witness. We wouldn't assign that type of case to them. We'd try to find a case that we didn't think was going to go to litigation, all that, so that you wouldn't have to use an expert. And we do have cases like that experts aren't required to advocate and to take on a case. So, but if it does, we want to screen to make sure that it's something that you could actually do. Could you take a case that might have a litigation component? Sometimes some of the attorneys are like, I want to have a case that I litigate, so it just depends. But we definitely don't want to have. We wouldn't want you to take a case if you didn't have the means to get the expert, if it was going to be a really like complex case. So going back to the cost of experts, evaluators, independent educational evaluations, they're authorized by the LEA, are paid for by the LEA, and they're at predetermined rates. Firms may pay cost of evaluation if no IEE or IE rates do not cover the cost of preferred evaluator. Again, we rarely have that happen, and we asked for that. Would be like they don't do an IEE. Like, I'll give you an example. I had a case where we got an IEE, but then it was like a year had passed, and then we needed another IEE, but we already used the school IEE, so Judge Lawson ended up paying for the extra IEE, and so we ended up absorbing that cost. But if we're referring out to a pro bono, typically we're going to talk about, getting the school to pay for an IEE. And most times, the pro bono is not going to take on the expense of paying for an IEE. So evaluators will typically charge an additional fee to testify if needed, and hourly fees for testimony range widely. So fees can be sought. You can try to get expert witness fees for cases with the new law in place. So when filing, you can choose mediation only, mediation and a due process hearing, and due process hearing only, and expedited due process hearing. I will say that typically we if we're going to a due process hearing, we choose the due process hearing only. We don't go to mediation beforehand. My feeling is that by the time we've gotten to, it's gotten to the point that we have to file a due process complaint, we're done talking. Like, let's go to the due process hearing at that point. I'm not going to go through, we've done all the talking and we've tried to make this work. I don't believe that that's going to help, and it could, depending on what the issue is. If you think you can mediate it, go for it. But if we're at the point where we're talking about placement, we're talking about kids not getting services, I need a hearing officer to rule in on, to weigh in on what's going on here. I don't want to go to mediation. What remedies are available? Any remedy that can address the denial of FAPE is possible. Prospective remedies include placement, increased services on the IEP, addition of services and accommodations on the IEP. Retrospective remedy is called compensatory education, or what we like to call comp ed. Comp ed is the term for remedy for past denials of FAPE. In DC, compensatory education must place a child where he or she would have been but for the LEA's failure to provide FAPE. So, for example, let's say, go back to the issue with behavior. Oh no, let's not do that one. Let's do an IEP where academic services are missing. Let's say kid has an IEP and hasn't had a special education teacher all year long, so they haven't got any specialized instruction all year. They're being taught by the general ed art teacher, math, science, reading, everything, and they have not got any hours, and they have a full-time IEP. So if they've missed all that time, and then let's say we get to a hearing, or let's say we get to the point of, we're about to litigate, and we say, well, one of the things we want the kid to get the education that they missed for that whole year. We want hours. We want time for them to make up those past services, so like back time for education. So we want them to have tutoring services. We want them to have that compensatory education, or the services that they didn't get, because they didn't get the services. They didn't get FAPE for a year because they didn't have a special ed teacher. Their IEP wasn't implemented. So if that we prove that, then we want comp ed. So one thing I will say, I can't remember, how much time do I have? Okay, great. So one thing I will say is sometimes you may not be going to, this is a side note, you might not go to a due process hearing, but this kid has missed a whole bunch of hours and the school is like, well, we're not mainly a DCPS school, but they might say, well, we're not going to admit that there was a denial of FAPE. We're not going to admit there's a denial of FAPE there, so we don't want to get on that train. But missed services, which is essentially comp ed, but it's a different term that doesn't mean there was that doesn't mean that there was a denial of FAPE. And sometimes you can get the school to say, okay, well, what about missed services then? And they will award you missed services just as long as you're not saying there's a denial of FAPE and there's any harm, and you can still get the hours. That's in the case where you're not going to a due process hearing. If you're going to a due process hearing, you're asking for comp ed because there has been a denial of FAPE. And it can include tutoring, speech and language services, mental health services, transition services, mentoring, technology, and software. And again, we know and we use comp ed providers often, and we can recommend comp ed providers. Yes.
Because what you said about the missed services, which really just seems like sort of a rhetorical difference, is that sort of a settlement tactic you might use? Or you might initially send a demand letter, like you were talking about the one attorney who represents 10 charter schools, like you might send that attorney a demand letter and say, like, okay, we've now figured out the IEP going forward, but there's still these backward-looking comp ed concerns.
Yes.
Here's what we want. And they might say, well, we're not willing to admit to a denial of FAPE, and so you might say, well, we'll settle if you call it missed services.
Yes, yeah, it's pretty much like the same, like, they'll say, well, they're missing, I might write a letter and I'll say, well, they've missed these hours, and so what we're requesting is either compensatory education or missed services. And you're like, well, what missed services, so missed services means all the difference. It's really the same thing, but they know that missed services doesn't mean there's a denial of FAPE. It's like you said, it's kind of like settling for, you still get what you want. They just don't want it to say, there's a denial of FAPE. So they may not say comp ed because that just sounds too legal, but missed services is like, okay, we agree, we did miss services and we will give you those services, but it's not comp ed. So it can work. So I also use that sometimes in IEP meetings where I know there's comp ed. I know that comp ed is going to sound so harsh to them because they know that means I'm saying that they denied FAPE. But I'm like, well, what about missed services? You've missed these, this is happening. And I think missed services are in order here. They're more likely to be responsive to that than like comp ed is what we need. But you can do that too as well. Not to say that you can't. You can. So some key questions to ensure your case in chief supports a compensatory education award for the time period in question. What should the IEP have looked like? What level of services should have been in place? What should the placement have offered? And as far as comp ed goes, when you're talking about a due process hearing and you're talking about what the comp ed award should look like, you want to make sure that you're talking to an ed expert or someone who has experience creating compensatory education plans and determining compensatory education awards. You want to make sure you talk to someone, an ed expert who has that experience, so they can talk you through because they need to explain this to a hearing officer. And if they can't explain it to a hearing officer very well, it could affect how much comp ed you get. I had a due process hearing last year where my expert, she created a comp ed plan. She explained what comp ed was, but then when the hearing officer started asking her questions, she got a little bit turned around, and the hearing officer was like, in his order, he was like, we got the placement, we got everything, but when it came to comp ed, he was like, I think there's compensatory education here, but I wasn't convinced how much there should be. And so you need to go and do another comp ed plan and then come back to the school and then have them develop whatever you come up with. So you want to make sure that you have someone who knows what they're doing when it comes to comp ed. It can't just be kid missed 10 hours, so kid gets 10 hours of comp ed. You have to, there's a whole science to it, and you want to make sure that your expert can explain what that should look like. One of the other things you want to make sure that's in there. It's like, had the IEP or whatever been appropriate, where would the child have been academically, socially, or functionally? I mean, I've had comp ed plans that say, like, had this child had, 2 years, the 2 years that they missed, they would be, 3 years ahead. They would be on the fourth grade level. They can get on some of these experts can get pretty specific about where the child should be or could have been. What does the child need to be put in the place they would have been, but for the denial of FAPE? What evidence do you have to support your claim? Is there a precedent that supports a novel comp ed request? I mean, it's a lot that goes into the comp ed. You want to be able to talk to someone about it, but you want to make sure you have evidence to support that services have been missed, that there's been a harm, and that there needs to be something to rectify that harm to that child. So what happens after you file? So 30 days, so you file, and then there's a 30-day resolution period. So by day 10, DCPS or the charter school has to file their answer. And they should file it on day 10, and then by day 15, you're supposed to have something called a resolution session meeting, and that's convened by the LEA. So you file your complaint. 10 days later, you get the answer from DCPS or whoever the LEA is. Then you guys are supposed to come together for a resolution session meeting, which is you're coming to the table. You go to the school, and you basically discuss the complaint. So you go, you have your complaint with you, and the school. You kind of like to the school, what do you got for me? This is what my complaint is. Where are we with fixing this? Yes.
You wrote DCPS files and answer, but this is really any LEA, right?
Yes.
Same process for charter.
Yes. Any LEA, DCPS, any charter school, it's the same thing. They don't get more time because they're a charter school. It's any LEA that you are filing, that they have to file their answer within 10 days as well. Okay, so you have the resolution session. The resolution session is a non-confidential meeting with the LEA. It's not settlement discussions technically. So you can bring someone with you to take notes, to talk about what what they're going to settle on. Resolution session meetings are interesting because you go to the table, and usually in the past couple ones I've been involved in, you go to the meeting, resolution session, the school team is there, you talk about the issues in the complaint. They're not willing to fix anything in the complaint, or they say they say you want a non-public placement, and then they're like, we'll give you an IEP meeting, maybe. And that's all that's all they're willing to do. And then you leave the meeting, and then you get a call from their attorney a couple of days later, and that's when the settlement discussions start. It's kind of like this weird dance. I haven't had a productive resolution session meeting, but sometimes they're good because you can get information. If you have a school team that's really mad that you filed something, I've had teachers come to meetings, and they get so mad, and they tell all sorts of information. And so they're good to, if they're there, you can ask information. They're still good, but usually it's not usually where a resolution happens. It's usually after that, where there's this it's kind of like, I feel like it's kind of like playing hard to get, kind of dating, where it's like, you know what I want, and then it's like, I'm going to play hard to get, and then you come and call me, and then when you call me, then we'll talk, and then I'll decide whether I want to go out with you or not. It's kind of like that. That's what I feel like. But then there's a pre-hearing conference, and then the pre-hearing conference, it may occur at any time. The pre-hearing conference is a conference with the hearing officer and the attorney for the school, and you guys kind of lay out how this hearing is going to go. So it's led by the hearing officer. The hearing officer will go through your complaint and summarize your issues and review the issues. They can kick out an issue right then and there at the pre-hearing conference. So you want to be able to explain, what your issues are to the hearing officer. If they have questions, they will issue a pre-hearing order. They will ask about what witnesses you're going to call. So those are the things that happen at the pre-hearing conference. If you could ask the hearing officer to make orders at the pre-hearing conference, or let's say you requested records and you never got them, you can ask at the pre-hearing conference that the hearing officer order that records be provided. You figure out, like I said, what witnesses and what day the hearing is going to be. And those are the things that happen at the pre-hearing conference. And then after that 30-day period ends, then there's a 45-day litigation period. And that's when the 5-day disclosures are due. We talked about the evidence that you can include. That goes into what we call the 5-day disclosures. And that's when you disclose all the evidence you intend to use. And that's when the LEA also discloses all evidence they intend to use for the hearing. It's due 5 business days before the hearing. The hearing officer will tell you how he wants to receive that information, typically in email and in a binder on the day of the hearing. The hearing is conducted like a regular trial, except for you're sitting at a desk, and there'll be openings, there'll be closings. The petitioner will put on their case, respondent will put on their case, and then there'll be closings. Hearsay is admissible. Witnesses may testify by phone, although you want your client to be there. The whole proceeding is conducted while seated around a table, like I said, and all documentary evidence and disclosures is admitted at the beginning of the hearing unless there is an objection to it. And sometimes in the pre-hearing order, the hearing officer will tell you how he wants to hear motions on like the disclosures and things like that. After you file the hearing, after you file, you've had your hearing, the hearing officer decision is due at the end of that 45-day litigation period. And at that point, depending on what your decisions, you can appeal to federal district court. And that's it. Anyone have any questions? I was kind of shocked by the ending myself. Thank you. I have one question here.
Let's read from the card.
Do services IEPs? Oh, yes, yes. I will read the question out loud, just so that everyone who might want to know the answer to this question. Do services IEPs transfer with students when they change schools? So if they go to DCBS to DCBS or charter school to charter school. And yes, they do transfer when they go from different schools. So if a kid is in Anacostia High School and then they go to Ballou High School, then their IEP goes with them. If they go from a DCBS to a charter, if they go from charter to DCBS, the IEP goes with them everywhere. That is a legal document that follows them wherever they go unless they're exited from special education services. But yes, that IEP will follow them wherever they go. Yes.
I know we said that when there's no more legal issues, that's kind of when you end the relationship. Mm-hmm. But if you're tasked with setting up an IEP or initiating a final course, do you leave a couple months to make sure that the school's doing what they're supposed to be doing, or do you say kind of, great, we're in place, fine?
Yeah, that's a good question. The question is, when you're closing out a case, do you stay on? I mean, once the IEP is set up, you've got everything in place, do you stay on and wait a little while to see how things are going, or do you just cut the case off and just end it? And it's really your discretion about where you feel the case is. We definitely will have cases and we're like, okay, well, we'll keep it open for another 30 to 60 days just because we want to make sure things are set in place, and then we'll close it out. Sometimes you might say, everything looks good, and you don't need me on here anymore. Then we'll close out. One of the considerations is where the client is and their level of advocacy for themselves. And so if they're able to do it, we'll close it out, call us back if you need more help. But if it's like, I'm not really sure, or the school is iffy, then you can stay on. So.
And just piggybacking on that, I think being clear with the client when the representation is ended is the key part whenever it actually happens, right, depending on the case.
Yep.
Thanks, Janine. Thank you. Thanks, everyone, for bearing with us. Thanks for those viewing at home or at their desk in the future. Please do complete the surveys if you have any capacity and bandwidth left to get those completed and send them over to Alyssa on your way out. We do have those 3 special education cases that I mentioned earlier. If you're interested, let me know. I have some interest, and so I'll be talking with folks, but if you haven't let me know, please do. In addition, I just want to mention again, there's a lot of resources. I was reading from that table of contents of your manual and that flash drive. We'll have that on the website. There's a lot to be looking at in terms of resources, and so the takeaway for today, again, was that you're becoming familiar with this area of law. You don't have to be an expert to get started, and we're here to support you along the way. So thank you so much for your time, and who knows what the weather is like outside, but I hope you guys enjoy it and make it to your next destination safely. Thanks so much.